Appeal in the matter of the King on the application of Jwanczuk and the Secretary of State for the Work and Pension.
Good morning, Mr. Sheldon. Sorry, hope it hasn't been inconvenient. We're sitting a bit early. The reason is that one of us, I won't say whom so as not to embarrass Lady Justice Elisabeth Laing, is walking for charity this afternoon and we need to rise promptly at 4:15. It did occur to us this is the sort of case which that last quarter of an hour might matter, because I know it's been listed for an hour and a half, but we read the day and a half. But we read the papers very carefully, and I would be slightly surprised if we couldn't get through it in the day. But let's see how we go.
My Lord, I think both counsel we're anticipating that it will take a day and a half. But
well, we'll see. I mean, we're not holding you to it, but
I take on.
Whoever, I forget who gave permission, but they thought it was a day and a half, so they may well turn out to be right. Wasn't it? Was it?
It was.
Oh, of course, the permission was given below. So
it was the judge.
Yes, okay. Right, off you go.
So, my Lord, my ladies, I appear in this matter on behalf of the Secretary of State for Work and Pensions, along with Zoe Gannon. My learned friend Catherine Callahan, KC, is leading Tom Royston, and they represent the respondent, the claimant below, Mr. Daniel Jwanczuk. Just in terms of housekeeping, just want to make sure that you have the core bundle, a supplementary bundle, and then an authorities bundle.
Well, two bundles of authorities.
Two bundles, yes, I have it online, but yes, there are two bundles of authorities.
Just to get one gripe out of the way at the moment, there, as index suggests tabs, but there aren't any tabs in the bundles. I don't know who's responsible for putting the bundles together, but could they make a note of that for the future? Because Council will at Pom say, go to tab 27. And...
I've got tabs.
Oh, have you?
Yeah.
Oh, I see, yes, in the authorities we have, but not in the main bundle.
Not in the main bundle.
No. Okay, so page references rather than tabs, please.
My Lord, there is one other little package of statutory provisions I want to hand up, just so that you've got it for completeness.
Do you want to do that now?
If I do that now. So when I take you through the legislation, we've got everything.
Thank you. I'll put in the authorities bundle now, because otherwise it's a bit lost. And I think,
Lord, if you put it at
not that it matters, I'll just put it at the back, but anywhere else.
It may be more convenient at the front if you're using, because that's where I'm looking at, or these are statutory provisions.
Yes.
And am I correct in observing that at least one member of the court is using an electronic?
I have got the hard copy as well.
What would you prefer, my lady?
You go with the hard copy.
I'll go with the hard copy.
Sorry, and the other thing, which is no fault of anyone's, but will slow me down, is that the bundles, the prongs don't meet in the middle. That happens. It's part of Sedley's law. Yeah.
So, my Lord, this is an appeal from the decision of Mr. Justice Kerr allowing a judicial review claim.
We were having that very discussion.
No,
Kerr.
it is Kerr, and I should know that because he used to sit in the next room to me. So this is an appeal from the decision of Mr. Justice Kerr allowing a judicial review claim from the claimant against the Secretary of State's decision not to pay him bereavement support payment, or BSP for short, following the death of his wife, Suzanne, or I think she was known as Susie Jwanczuk. The conditions for BSP are set out in primary legislation, sections 30 and 31 of the Pensions Act 2014. In his order, the learned judge declared that section 31D, Pensions Act 2014, should be read and given effect so that the contribution condition is treated as met if the deceased was unable to comply with section 31(1) throughout her working life due to disability. That order was made pursuant to section 3(1) of the Human Rights Act 1998. The judge found that as drafted, section 31D contravened Article 14 of the European Convention of Human Rights, read with Article 1 of Protocol 1. The Secretary of State challenges that decision on a number of grounds, and I'll just read those out. Firstly, that the court
Do you need
urged-
to read them out, or we know what they are?
You know what they are.
Yeah.
But I mean, there were 4 grounds of appeal covering four different areas. My submissions will cover the following grounds. So just to let you know, firstly, I'd like to deal with some headline points, then look at the legislation, then deal with the background to the legislation in issue, which is the historical background, and then the 2011 consultation, then a brief factual background of the claimant and his wife, then a discussion about O'Donnell in the Northern Ireland Court of Appeal, and then I make my submissions on the grounds of appeal. So if I can start, my lord, with some headline points, and I have 3 key headline points. Firstly, that the judicial review challenge by Mr. Jwanczuk was to primary legislation concerned with social security welfare benefits, where the entitlement conditions are clear. Those conditions were passed with the assent of then Her Majesty's opposition in circumstances where it was understood that the spouses or civil partners of those unable to work due to illness or disability would not obtain the benefit, as that point had been specific, as in if they'd been unable to work and had not complied with the contribution condition, as that point had been specifically raised in the consultation process for the legislation. The status for Article 14 purposes, assuming that it is an accepted status, and we argue that it isn't.
Is this all part of headline 1?
This is headline 1.
Yeah, okay.
Is disability plus, that is, it's not disability per se, but disability and something else, which means it's not a suspect class. And against all of that background, in the circumstances when considering a convention challenge, great deference should be afforded to the decision maker. The intensity of review should be relatively light, and the court should apply the manifestly without reasonable foundation approach. I appreciate it's a long headline point, but it leads to that.
Yes, I think you wouldn't get past the tabloids.
Second point is, the Secretary of State acknowledges that a level of respect should be afforded to the judgment of the Court of Appeal of Northern Ireland in O'Donnell, but the High Court in England and Wales and this court is not bound by that decision and is not required to follow it. And thirdly, the discrimination claim was based on the Flimanov's principle that unlike cases should not be treated alike unless they are justified. We say that test was not made out, that there was strong justification for the treatment. Firstly, justification, and I will obviously repeat this as we're going through the submissions.
What's the point of telling us it now then?
Well, no, my lord, I'm giving you in summary my points, and then I'll go.
We know what they are. That's what the skeleton was for.
Well, my lord,
But, all right, sorry, I won't.
I'm going to seek-
You keep going, Mr. Selden. I'm sorry.
Thank you.
It's a question of whether I have to write it down.
No, well, my lord, that's a matter for you. My lord, the aims of the legislation and the reason why there is justification here is because the contribution condition is there to reward work through the benefit system. The government is committed to the contribution principle, that people should make national insurance contributions by working and receive certain benefits in return, and they consider that to be a central policy principle. Secondly, there should be a simplified benefit system in circumstances of bereavement to ensure that administrative cost and complexity can be reduced and claimants can be paid as quickly as possible when they most need it. And thirdly, the system is structured in such a way as to ensure certainty and transparency for individuals in understanding their entitlement to benefits, which will assist with planning for the passing of their spouse, partner and now cohabitee as the law has changed.
Yes, I'm sorry if I was shirty just now. It's just it is often quite difficult to know as well which submissions to record. What was the first one again?
My lord, the first one was to reward work through the benefit system.
Yes, I see.
That's the contribution principle, which I'll also be describing as something for something.
It might help if we just told you now our provisional view about the O'Donnell issue. It might or might not affect how you shape your submissions. We've all had a look at, not in one of the authorities we were given, but one which is referred to on the ones we were given. I've now forgotten the name, but it's Thank you.
Abbott and Philbin.
Abbott and Philbin, which is the Court of Appeal case about a tax authority from Scotland. What happened there, and it's clearer if you actually read it rather than simply read the short summary of it in the case in Dean, is that the Court of Appeal thought that the Court of Session in a house was wrong, and said so in courteous terms, talking about serious doubts and pointing out some of the difficulties in the arguments, but nevertheless treated themselves not formally as bound. Everyone agrees they're not bound, but for reasons of comity and because tax statutes like social security statutes apply across the United Kingdom, they thought the right thing was to follow it and give permission to appeal to the House of Lords, which is what they did, where the decision of the inner house was reversed, effectively. Sorry, it wasn't reversed, overturned, and that seems to us to be strong authority about how we ought to deal with this situation if we take the view that O'Donnell was wrong, or at any rate, there are very strong arguments that it is wrong. As I say, you may try and persuade us that that's too craven and that we ought simply to disagree with it, but that isn't, of course, taken in that case. And I think you might, if you haven't already, just care to look at it and explain why we shouldn't do what the Court of Appeal in Abbott and Philbin did. Because otherwise, I think that's what we would be minded to do.
I do appreciate that. I mean, one point I'll just make at the outset on that is none of these cases, and I don't think any of us have found a case, concerns a Human Rights Act challenge.
Can't see why that would make a difference.
I mean,
I know you do say something about why it would make a difference,
that would be, especially when one is dealing with here, where the remedy that's being sought is either a reading in to change, effectively to read in language into the legislation under the Human Rights Act, or to actually declare incompatibility. My submission is that a different approach ought to be taken by the courts.
Yes, okay. Well, there we are. I thought it's better to lay that out, partly so that your junior can have a quick look at Abbott and Philbin while you're talking.
That's extremely helpful. Just to conclude my headline points.
Oh, right. So I'd written down there were three.
There were three of those, and I just wanted to conclude that point, and then.
Oh, I see. Sorry, I thought you'd finished. My mistake.
Lord, the how to draft the legislation and how to set the conditions for bereavement payment is fundamentally a matter for Parliament, and the second and third points about simplification and ensuring greater certainty are, we submit, of especial importance at a time of a bereavement when complexity and uncertainty in determining entitlement to BSP should be avoided. And we say that there is no proxy that is administratively simple for the Department for Work and Pensions to apply so as to meet the exemption, which is essentially what the claimant is asking for, and to work it out on the facts of any individual case would, we say, require considerable time and effort at a time when simplicity and certainty are of great importance, and fairness demands that there would be equal treatment of different claimants in those circumstances, but in fact the knowledge that people may have of their spouse or partner's working life may well be very different. So those are my headline points. If I can now take you, my lord and my ladies, to the legislative scheme in tab 7 of the authorities, we have the Pensions Act of 2014, particularly of section 30. So that's at page 42, I believe. If my pagination on the electronic is different from the hard copy, please let me know now so that I will make those adjustments.
But we've got tabs in the authority.
You've got tabs, yes, you've got tabs. I will be taking you to pages at various stages.
Well, it's page 42 in my volume.
And mine.
Well, my lord, I am grateful. So we can see there that a person is entitled to a benefit called bereavement support payment if the person's spouse, civil partner or cohabiting partner dies. The language or cohabiting partner came in 2023 as part of an amendment to the legislation following a challenge in a case called Jackson. But the original language was person's spouse or civil partner. And if I use in my submissions, if I say spouse or partner, it's intended to cover the whole range. So if their partner dies, and then B, the person is under pensionable age when the partner dies, the person is ordinarily resident in Great Britain when the partner dies, and the contribution condition is met. So very clear language. And then the contribution condition we see at section 31. The amount of benefit is set out in regulations, and you see that is empowered by subsection 2. You also see that a person is not entitled to the bereavement support payment for periods after they've reached pensionable age. And then on to section 31, which sets out the contribution condition. Sets out very clearly for the purposes of section 31D, the contribution condition is that for at least one tax year during the deceased's working life, he or she actually paid Class 1 or Class 2 national insurance contributions, and those contributions gave rise to an earnings factor or total earnings factor equal to or greater than 25 times the lower earnings limit for the tax year. So clear on the face of the statute what the contribution condition is to satisfy the payment of the benefit. So they have to have actually paid Class 1 or Class 2, which is either employed or self-employed national insurance contributions, which means not credits. And you can have credits if you're in receipt of certain benefits, which are relevant, for instance, to the state pension, to the accrual of the state pension.
Did we do we have in the bundle the provisions relating to credits? Yes, in fact, I think they're the next tab, aren't they? Yeah. Yeah. Okay. Are you going to take us to those?
I'm not planning to take you to those, but essentially.
But they're there.
But they're there. The point is that it's actually paid national insurance contributions.
Yes, it's just there was some reference in some of the judgments to credits.
Yes.
And I wanted to understand how they worked.
Yes.
But that's fine. I can find it.
And it's Class 1 or Class 2. You may be familiar with Class 3 national insurance contributions, which are voluntary payments that people often make payments to, or are allowed to make payments to fill the gaps in their national insurance record, primarily to achieve a state pension. And these were matters that were part of the consultation and part of the debate in Parliament. But so there's a specific condition of actual payment of Class 1 or Class 2, and there's a reference to, and it's in 1 year, not throughout the course of one's lifetime, it's in 1 year, and those contributions gave rise to an earnings factor equal to or greater than 25 times the lower earnings limit for the tax year. That is it. This is a more complicated provision, but it's explained in Helen Walker's witness statement at paragraph 9 of the supplementary bundle, page 42. And just to tell you simply, an earnings factor is derived from gross earnings between what are the lower earnings limit for national insurance contributions, which is currently, or was currently when this case was argued, below £123 per week, and the upper earnings limit of £967, and they must have paid national insurance in at least 1 week. To actually pay national insurance contributions, you have to have earned over £190 in 1 week. So that's called the primary threshold at which actual payments of national insurance are made. So for 1 week, you have to have earned £190, either employed or self-employed, and paid national insurance contributions. And you have to have earned during the course of that year amounts that give rise to 25 times the lower earnings limit. So you don't actually have to pay national insurance contributions on that other amount, but it basically, in a sense, balloons your payment into a larger amount for the purposes of benefits. Just working out 25 times 123 is £3,075.
Sorry, 100. What times 23 is?
So as it says, it's 25 times the lower earnings limit for the tax year.
Yes, but
So 25 times, it's £123 is the lower earnings limit.
Yeah.
Oh, it was, and I'm talking about for that period.
123 times 25 is what?
£3,075.
Thank you.
So during the course of a tax year, and let's just take that, one had to have earned £190 in 1 week, so that you actually paid national insurance contributions. But over the course of the year, you earn effectively just over £3,000. And that would give you the national insurance contributions sufficient to get the bereavement support payment for your spouse. The earnings factors is explained there at section 31.2. You have to go to section 22 and 23 of the 1992 Act, and we've got the provisions there for you if you need those. Parliament therefore has prescribed very specific conditions, but at subsection 3, Parliament has also provided an exemption specifically provided for the fact that the contribution is to be treated as met if the deceased was an employed earner and died as a result of either a personal injury, as defined by the 1992 Act, or a disease or personal injury of the kind mentioned in section 108 of the 1992 Act. And then there's a reference to employed earner is as defined in section 122 of the 1992 Act. And just to show you what that is, that was one of the documents I handed up this morning. It's on the first page, my lord, and you may be familiar with this in any event. So this is dealing with
last night.
This is dealing with the prescribed exemptions or exceptions. Employed earner, you see on the front page of this little bundle, is section 2 of the 1992 Act. An employed earner means a person who is gainfully employed in Great Britain either under a contract of service or in an office with earnings. So there has to be employment. I'm not going to go into the detail of the other conditions for that, which are the industrial injuries benefit, but you've got the provisions in that little packet. So, but what one can see is that a very limited set of exceptions has been specifically provided for by Parliament, where someone is actually working but has died before they have been able to achieve the national insurance contribution limit, which would otherwise satisfy section 31D. And that exception, or those exceptions, will require anyone applying this to look at a particular event rather than considering the whole working life of an individual, as is what is sought for and found by the court below. So, in summary, what we have in the legislation is that we have very specific conditions of entitlement. It's not a means-tested benefit. It's based on a very clear contribution condition, and those conditions are simple, easy to understand for anyone who is faced with the situation where their partner dies, and easy to ascertain for those who are administering the system. You'll also see that it is set at a low level. I think in the parliamentary debates, which we've included very short extracts in the bundle, maybe the lowest level for any contributory benefit, but it's clearly set at a low level because it's only 1 year in one's working life that one needs to have paid the national insurance contribution, class 1 or class 2. The contribution condition is not related.
Can I just ask one question about that? You say simple and easy to ascertain. If your spouse dies in, let us say, their 50s, and you've been married for, let us say, 10 years, and during that period, they have not been paying contributions, you know, because they haven't been working.
Yep.
How will it be easy for you to ascertain whether 20 years ago, before you knew them, they had a year when they were paying contributions?
Well, firstly, you can ask the Social Security Department.
Will it be easy for them to ascertain?
It'll be easy for them to ascertain because you either have paid them or you've not paid them, and that will be on their system.
But you'd need their national insurance number.
You'd need their national insurance number. So, and you can, my lord, just because I've actually happened to look at this myself for a completely different purpose, you can go online if you have there's something called there's a gateway with a gateway number and ID. Anyone can go on to see what national insurance contributions they've made.
Yes, but for them personally, isn't it?
For them personally, but if you had access to that, I'm saying you can ask, you can call up the Social Security, Department for Work and Pensions, and they can give you the answer to that. But you can look at it yourself if you know your partner's gateway number. That's all.
Yes, I'm just. It's quite as simple as that. In the kind of example I put to you, which is perhaps not absolutely standard, but not a particularly implausible one either. You're very unlikely to even know your wife's or husband's national insurance number.
Well, my lord, you can if you make contact with the department where there has been a bereavement,
Yeah.
or you apply for it, they will say they haven't made the contributions. They either have or they haven't. It's a simple matter. And I'll show you here the decision that was taken.
But in order to apply, do you have to give the national insurance number?
That I don't know. I can find that out. But what you'll see here when we look at the application, the decision was made within a matter of days.
Yeah. Okay, but the key point is, subject to possible difficulty about not knowing the national insurance number, if you make the application, the records will exist going back.
The records exist.
The records going back,
yes.
as long as you know.
Yes, because they are relevant to state.
Of course,
to the state pension.
Yeah.
Also, the amount of benefit that you the contribution condition is not related to the employment or contribution situation of the living partner of the claimant for the application. It is based on the contribution condition of the deceased. And then the amount of benefit received is simple to understand. There are two rates. If you're not responsible for a child under the age of 20, you could get a lump sum payment of £2,500, followed by a further 18 monthly payments of £100. If you are responsible for a child under the age of 20, you could get a lump sum payment of £3,500, followed by 18 monthly payments of £350. And that was the situation in O'Donnell, where you had a father with responsibility for children. That is the legislation.
Sorry, this we'll have to do it at some stage, and if it's going to be a complication for you to do it now, just say so and you can do it later, or Mr. Callahan can. But I've just had a quick look at tab 8, which is the one which sets out credits, page 46.
Yep.
And it starts for the purpose of entitlement to any benefit, by virtue of a person's earnings or contributions. He, that must be that person, I suppose, shall be entitled to be credited with earnings equal to the lower earnings limit then in force. I'm sure there's an obvious answer to this. Why does that not apply to the exercise you do under Section 30?
Because
Talks about actual payment.
If you remember,
Yes, I see. Well,
You
I said there was an
pay.
obvious answer.
Yep.
It's just
Yep.
I hadn't seen it. Yes, I see. Thank you.
my ladyship got there first. So there has to be an actual payment. That's the legislation that is in issue.
Yep.
That Parliament
Thank you.
enacted. Lord, the background to the bereavement payment scheme historically is set out in a decision of Baroness Hale in a case called McLaughlin in the Supreme Court, which you have at tab 39. Tab 39, a case of McLaughlin. It's dealing with the previous regime, but it sets out in some detail the history to this. I'm not going to take you through it now, but it may be.
So I'm just making a note. Where is it?
Tab 39, my lord. And it was a case involving a challenge to the eligibility requirements for what was previously known as widowed parent assistance, which was part of the earlier bereavement support regime. So previously, there were 3 benefits that people could potentially obtain, one of which was called the widowed parents allowance, and it didn't allow payment to unmarried parents with children. And then there was a challenge to it, which ultimately went up to the Supreme Court. And just for your note, paragraphs 4 to 12 set out the background in the
Yeah, thank you.
to all of the benefits. At paragraph 11, and this was a case which originated in Northern Ireland. Paragraph 11, Baroness Hill refers to the fact that the scheme has been radically changed yet again by the Pensions Act 2014 and the Pensions Act Northern Ireland 2015 in respect of deaths taking place after their implementation. And this gives you a nice summary of what has taken place.
Thank you.
Bereavement payment and widow payment parents' allowance have been abolished and replaced with a single bereavement support payment available to all bereaved spouses and civil partners, irrespective of age. It's paid as an initial lump sum, etc. The rates are higher if the bereaved person is pregnant or entitled to child benefit. The object is to focus support on the period immediately after bereavement.
So if you were to read this out, we not read to ourselves how much you want us to
You
read.
can read to yourself there. That paragraph 11 and paragraph 12.
Okay.
The
Yes, thank you.
important description at the bottom of paragraph 11 is, as before, entitlement depends on the simplified contribution record of the deceased and is not means tested. Longer term impacts are left to means tested benefits with some transitional cushioning. In other words, if someone whose partner is deceased, who themselves has no income or limited income, may be entitled to means tested benefits for their ordinary living expenses and so forth. That's not the purpose of the bereavement payment. So there was consultation on the new statutory scheme. That's described in the witness statement of Helen Walker, tab 6 in your supplementary bundle, paragraphs 26 to 49. I just want to take you to a few of the documents, a few references within the consultation documents themselves. At page 155 of the supplementary bundle, page 155, you see a document headed Public Consultation, Bereavement Benefit for the 21st Century, document that's presented to Parliament by the Secretary of State. And at page 164, so internal page 12, but page 164, they set out the principal policy aims. You should have a box on that page. You'll see the bullet points there. They should be simple to understand and to claim. They should provide fast, direct financial help for immediate needs following the bereavement of a spouse or partner. They should give recipients the flexibility they need to regain control of their situation. There should be additional support for families. They should allow recipients to access financial and work-focused support provided by universal credit. They should be fair and promote self-dependency. The following page, you'll see the third paragraph, and then there are two bullet points where they say the bereavement benefits do not currently meet all of the principal policy aims for the following reason. The complexity undermines their effectiveness as an insurance policy. It's very difficult for people to anticipate whether they will qualify and how much they will receive. At a time of significant emotional stress, when clear thinking can be very difficult, this is particularly inappropriate. And then the second point is relating to disincentive to maintain contact with the labour market. But it's the first point that I particularly rely on as to the importance of a simplified system. we see at 195 the government response to the public consultation, 195. You'll see the heading on that page, government response to the public consultation. And at page 200, towards the bottom of the page, you see a heading, simplifying entitlement conditions, at the bottom of the page. They're setting out some of the comments made in the consultation. Contribution conditions. There was broad support for the proposal to simplify national insurance contributions, though some organisations qualified their support. And then they set out some of the responses.
So when it says to simplify national insurance contributions,
under the previous regime, there was a complicated set of arrangements for the different benefits. And
yes, I thought it was about simplifying the benefits, not simplifying the contributions. But
no, this is so what the they had different requirements for different benefits, and so what this proposal was going to be was we're going to make one benefit, and we're going to have within it a simplified contribution system.
It is no, it's just rather oddly worded, but that's fine.
And it says, going over the page, 201, under the first bullet point, where concerns were raised about proposed changes to contribution conditions, these mainly focused on the exclusion from coverage of those who had not paid enough national insurance contributions, including those who had supported the home rather than being in paid employment, those who had been unable to work due to illness or disability, those who had recently left full-time education. Some respondents made suggestions for increasing coverage, including taking national insurance contributions of both the surviving and deceased spouse into account, taking national insurance credits into account, making the benefit universal. Conversely, some respondents described the consultation proposal as too generous, not adequately rewarding work, and not being faithful to the contributory principle. But what you can see, it was very clear, and this document is presented to Parliament, so therefore we have to assume it's therefore taken to be understood by Parliament, that there will be categories of individuals whose spouses, partners will not qualify, where their deceased partner had not paid enough national insurance contributions. And that would include the very category that the claimant forms a part of, or argues that he forms a part of. That is, those who've been unable to work due to illness or disability.
And just so I've understood it, would the second of the bullet points summarising suggestions for increasing coverage, that's to say taking national insurance credits into account, would that have met the position of those unable to work due to illness or disability?
Yes, because if they were also in receipt of one of the I'll call it the incapacity benefits, because that would give rise to a credit.
Yes.
But I'm making this point so that when I make my submission, that Parliament was aware of this particular category and of the particular concern that is expressed in the litigation here and in O'Donnell when they set the contribution conditions. And I say that that's something which you ought to take into account as part of your reviewing of any justification. The matter had been put to the minister, the relevant minister, Lord Freud, who was taking the legislation, was dealing with the consultation, then was taking the legislation through Parliament. and you see the submission at page 186, just so that, again, you're aware that the government was aware of this particular category. 186 is the beginning of the memorandum to Lloyd Freud, and the particular reference to this category is at 188. And essentially at paragraph 11, you've got a similar paragraph to what we've just been looking at in the formal consultation response. Page 188, paragraph 11, dealing with simplifications. Some people did express concerns about people who might not qualify. Examples included, and the second bullet point, individuals have had a history of illness preventing them from working and paying sufficient contribution conditions, such as young cancer patients. And then at 12, you had the how maybe to address that, taking into account national insurance credits, etc. Then it has, conversely, a small number of respondents criticised the perceived weakening of the link between contribution histories and the value of bereavement benefits, undermining the something for something principle of the national insurance system. Some people suggest the link between the bereavement benefits they received and their late spouse or civil partner's national insurance contributions played an important role in their experience of the payments, avoiding the stigma associated with being on benefits. Now, a specific proposal was put to the minister to say, do you want to basically allow people to have the credits included? And that's for that whole class, so the 3 bullet point classes, not just those unable to work. And he said no, and you have...
Sorry.
There was a...
Wait, no, wait. It's just my wanting to be informed about national insurance credits. I understand entirely that you would get national insurance credits if you were unable to work through disability. In what other circumstances would you get national insurance credits? Are you saying you would get them in each of the 3 circumstances identified in paragraph 11?
I'll just confirm that. I believe the answer is yes.
Yes.
Thank you. Even the 3rd one?
I believe the answer is yes, because the answer given essentially was if you allowed credits to all of those categories, yes, 99% of people would qualify. But I'll confirm that over lunch for you.
No, I'm not questioning it. I just wanted to feel firm ground under my feet.
My lord, the readout from the discussion around this from the minister is at page 199. And you see an email from the Assistant Private Secretary to the Minister.
Sorry, not 199.
Oh, sorry, 193. I apologise, my lady. 193. Lord Freud agrees with all 4 recommendations set out in the submission. Firstly, to base entitlement to bereavement benefits on any 1 year's national insurance contributions paid by the deceased spouse or civil partner only. Not to count national insurance credits towards entitlement, maintain the current earnings factor of 25 times, disregard class 3 national insurance contributions when determining entitlement. So, but again, it's clear that this particular category was drawn to the attention of the minister, and there was no decision taken to find a way of exempting them from the general scheme.
It would have been possible, presumably, to allow some kinds of national insurance credits, or perhaps more accurately, national insurance credits to which you were entitled for particular reasons, such as disability.
Yes, I mean, that absolutely, my lord.
So, but not, for example, where the spouse had chosen to stay at home.
They could have done that.
But that it doesn't appear from this that that particular variant was put forward. It was more
that particular variant was not put forward, but at the same time, my lord, we don't have the situation where the minister, who is aware of this category, because it's drawn to his attention, says we need to carve out something for that particular group. And that's the same point, my lord, not just for the minister, but also for Parliament.
No, fine, thank you.
Yeah, my lord, it would have been possible to do that. I'm not saying it wouldn't have been possible, but it was obviously a decision not to do so, and then a decision of Parliament not to do so. And we say that goes to the issue of deference. So, well, that's the all I want to say about the legislative background. And if I can move on, say very briefly about the factual background. Mr. Jwanczuk's first and second witness statement provides a lot of material relating to Susie's life and her disability and her challenges. A summary of the facts is set out in Mr. Justice Kerr's judgment, paragraphs 3 to 6, but the High Court did not, and this court does not need to, determine whether, as a matter of fact, Susie was unable to work. That would be a matter for the first tier tribunal to consider if Mr. Jwanczuk, if we fail on our appeal, because then it will be a question of, depending on how the order is structured, does he qualify? But that would be a question of fact for the first tier tribunal.
I think it's part of your argument, isn't it, if it isn't, that although it's certainly not necessary to determine it, seeing how it might play out in a case like hers is illustrative of some of the points about difficulty.
Yes, I do say that.
Yes.
I do say that, but in terms of, it's not for you to determine, make findings of fact in respect of that. There is a set of proceedings in the first tier tribunal, which has been stayed pending the outcome of this case. Unlike in O'Donnell, where it was conceded by the relevant Northern Ireland department that Mrs. O'Donnell had been unable to work throughout her working life as a result of a disability, that point is not conceded by the Secretary of State. And just a couple of points that we would note are that, and you see that in the evidence, is that, and I'm not seeking for you to make findings of fact on this at all, but just to draw to your attention, voluntary work was done by Susie. She carried out various administrative tasks, we understand, and also there are some caring tasks that she carried out during the course of her life. Now, Susie died on the 20th of November 2020. Following her death, the claimant applied for bereavement benefit on the 3rd of December 2020, and this was refused on the 8th of December. So a matter of days. And we see that on at page 3 of the supplemental bundle. We just have a we don't have a very good copy of the letter, but we have, you can just about see on the right hand side of this document, 8th of December. And you can see, thank you for your claim. The decision about your claim, unfortunately, you cannot get bereavement support payment. This is because your husband, wife, still partner did not pay enough national insurance contributions. If you have any questions about your husband's, wife's, or partner's national insurance, contact HMRC. That's the point that I was trying to make earlier. So I think I said contact the department, contact HMRC, who are have that information. What happens next? If you disagree with this decision, you can ask for a written explanation, ask for it to be reconsidered, or appeal. Other support, to find out other support you may be able to get, contact DWP Bereavement Service. But what can be seen from that is there was a very quick decision based on a simple test. All that is required is a review of the national insurance contributions records. The claimant sought a mandatory reconsideration, so essentially a review of that decision, which he's entitled to do. And you'll see that it was sent, I think, 9 months later, written by a law advisory service. And you'll see in the second paragraph, the grounds for this request are that my client's wife, Suzanne Jwanczuk, was disabled all of her life due to her disabilities. She was never able to work and pay national insurance. And this decision, this application was also refused. And you see the decision refusing it in the core bundle, my lord, at page 270. Page 270. You'll see the application for mandatory consideration basically upheld the decision, the initial decision. This is because it cannot be accepted that Mrs. Suzanne Jwanczuk paid sufficient contributions in any tax year during her working life. And then they set out the facts and evidence considered.
Yeah, and not every particular point.
No, you can see that. But it sets out you didn't satisfy the contribution condition. In her witness statement, Ms. Walker explains the extensive investigations that have taken place to understand Mrs. Jwanczuk's national insurance and welfare benefit record, and that involved going back through Department for Work and Pension and HMRC records between 1990 and 2020, and it was a very complex process because of the different bits of information that are held by different parties and the different references on there. Not in terms of national insurance contributions, but in terms of what other benefits did the claimant's wife have? Did she apply? So in terms of trying to find out whether or not she could or might or had in fact worked during that period of time.
I see all that, and I see why that's important. Again, to your, or I might call your difficulty argument, but just so to keep my head straight about this, that was an unnecessary inquiry on your view of the law.
Oh, absolutely. No, I mean, it wasn't done for the purposes of this.
Yes.
You consider it was done to see how does...
Exactly.
Well, first, how does one deal with the issue of was she unable to work during her lifetime?
Yeah,
how does
right.
one assess that?
Yes.
Where, and I'll go on to develop, there is no proxy for that. There is no benefit within the system which says you are unable to work.
Yeah.
So how do we work that out?
You're coming back to that later.
And I'll come back to it later. But
Okay.
that evidence,
Just give me the para references. I may have read it.
and I'm not going to take you through that now.
No, but just...
It's Helen Walker, paragraphs 15 to 23.
Yeah.
15 to 23 in supplementary bundle.
Thanks.
And then Sidoni Edie at 4 to 6.
Yes. Thank
But the conclusion of Miss Walker at paragraph 23 of her statement, based on the investigations, is to say it is very difficult to determine, based on information held by the government, whether or not an individual was unable to work throughout their life. And that's at paragraph 23, supplementary bundle 46. And that's essentially the point that I would wish to make on the facts.
you. Yes.
Moving on to O'Donnell, if I can, because obviously that's part of the factual and legal background, and I hear what you say with all this to a provisional view. That you find that, my lord, at tab 50 in the authorities bundle. I'm sorry that for some reason it's not in the core bundle, and it probably should have been. I apologise for that. But we have it.
No problem.
Tab 50. Decision of the entire court and judgments delivered by Lord Justice Stevens, now Lord Stevens. That was a case concerned with the Northern Ireland legislation. There was a case brought by a widow with children, and the I apologise, a widower with children, and the Northern Ireland Court of Appeal decided that the exclusion of the partner of a person with a disability who was unable to work throughout their lifetime was a breach of Article 14, and said that that could be read into the primary legislation. On the facts of that case, as I've already indicated, it was agreed that Pauline O'Donnell was unable to work due to her disabilities. That you see at paragraph 37. The justification discussion is between paragraphs 92 and 100. And I will come back to it, but I just highlighting that. And the remedy discussion is at 101 to 102. One of our grounds of appeal is that if you're against me on the merits, the remedy that was provided by the judge below was wrong. He should have made a declaration of incompatibility rather than reading in the language. As a result of that decision, and in terms of in order to respond to that decision, the Northern Ireland Department, and this is a devolved matter, so it's not a matter which is within the gift of those instructing me, the Secretary of State for Work and Pensions. This is a devolved matter. The case in Northern Ireland was argued or defended by the Department for Communities, which is the relevant Northern Ireland department, and that department responded to O'Donnell with its own decision-making process. And you see that they have a guidance document in the supplementary bundle at page 274, paragraphs 8. So, and this is supplementary bundle 274. Set out the background to the O'Donnell decision, explain what O'Donnell decided, and then they set out from page 275, from their paragraph 7, the future decision making, how they're going to deal with it. So at page 276, under the heading of evidence, at paragraph 8, they say, although there is no one benefit which would definitively prove a person could not have worked throughout their working life, where a system check shows the deceased spouse or civil partner had continuous entitlement to various benefits throughout their working life, the decision maker can allow the claim for bereavement support payment on the basis that the contribution conditions are met, are treated as met. Provided there are no gaps in entitlement to these benefits, an award can be made without contacting the claimant or obtaining further evidence. So they've taken a decision that they will treat that as a proxy, even though they recognise that that wouldn't definitively prove. And then they go on to say the absence of a claim to one of these benefits does not conclusively prove that the deceased was able to work. They may have been unable to work due to disability but didn't claim these benefits. And then they go on to say, and then they have a variety of other ways in order to avoid contacting claimants unnecessarily at what is a very distressing time. Preliminary system checks should be carried out.
So it's a one-way proxy, effectively. The para 8.
Yeah, and then if you read the remainder to yourselves, you can see they've come up with a system which will enable them to seek to satisfy the O'Donnell judgment.
How far through do we need to read?
Well, no, my lord, it's there. I don't think you don't need. You only need to know that they've set up a system. And what they have done there is, one, they've recognised there is no single benefit which demonstrates the person was unable to work. They look for evidence to see whether they had worked, such as or were able to work, such as a claim for job seekers allowance or other unemployment benefit, and then they consider evidence provided by the individual, including medical evidence or a statement. Now, Miss Walker.
Sorry, the risk of distracting you, but it's a self-contained point. I don't think you showed us the statutory provision that defines working life, but there is one, isn't there?
There is one, my lord. I'm not sure if we have that in the bundle, but it was discussed by Mr. Justice Kerr in his decision.
Okay, thank you. That's as long as it's there somewhere. Yes, but we are effectively going back to 16.
Yeah, one goes back to, I think it is 16. It is 16, and one therefore may be dealing with 50 years of someone's life. But certainly, it can be tens of years as to what they did or didn't.
Just having, I'm afraid, distracted you on that. Perhaps I can distract you one thing further. Many people at 16 continue in school education for another 2 years, or maybe leave school but go into some form of training.
Yes.
And then, of course, they may go on to higher education. During that time, you would not expect them to claim any work-related benefit if they were disabled but receiving education. They wouldn't be claiming the kind of,
well, or maybe not. It just depends on, you know.
yes, they may be not.
In the summer, for instance, they may have, you know, they may have claimed unemployment benefit. They may have been looking for work. They may be looking for work but didn't obtain it.
Yes, I see. Okay, I'm not sure it's important, but if it is,
but essentially,
come back to it
one
at
needs,
time. Don't let me distract you from what you're saying.
But essentially, one needs to go. One can. The situation may involve going back over 50 years.
Yes, right.
And also, it may involve you know, having conversation with the claimant during a period of just after, during their period of bereavement. Now, this approach is discussed by Helen Walker in her witness statement at from paragraph 54 onwards, so page 55 of the supplemental bundle, and just to explain, Helen Walker, at the beginning of her statement, I'll just tell you, she's the Deputy Director of Life Events and Disadvantage in the Poverty, Families and Disadvantage Directorate within the department. She has responsibility for bereavement benefits. She's had this responsibility for 5 years. Paragraph 54, she explains what happened in Northern Ireland. She explains what the memo sets out. And at paragraph 56, her view is the approach adopted by the Department of Communities appears to be a pragmatic approach to balancing the interests of minimising the administrative burden while seeking to give effect to the judgment. Arguably, the approach goes further than that required by the judgment in O'Donnell, as it may lead to individuals who are not, in fact, unable to work for the whole period being granted ESP. At paragraph 63 onwards, Ms. Walker sets out the challenges of having an exceptions policy. And I would like you to read that, not necessarily now, between paragraphs 63 to 69, where she sets out the challenges. So essentially, she makes the point that none of the benefits within the department decisively state that it was impossible for the person to work. One would need to analyse their whole working life to gather the information. What does the DWP do with respect to people who live abroad, for instance? How does one obtain the relevant information there? She makes the point, based on their own investigations in this case, how, in a sense, time-consuming and resource-intensive that process has been. You might have a situation where they have to give the benefit of the doubt to a claimant, which means that where those partners were able to work at some stage but no information is held by the department, they may get a benefit that neither Parliament, that Parliament didn't think they should be entitled to, and goes beyond the kind of the O'Donnell system. There's a risk of fraudulent claims, and I make it very clear we're not suggesting at all that what is being sought by the claimant
No, of course not.
is fraudulent. Then there's the issue of, which in a sense picks up maybe my Lord's question earlier in some ways, the deceased spouse or civil partner may have no knowledge of what happened earlier on in one's life, not just not know their national insurance number or whether or not they, had work, but they may know nothing about, or not enough in any detail of what happened at an earlier stage of their lives. What we have in this case is obviously a very close relationship from a very young age, where there was more intimate knowledge of the intervening years. That may be unusual, but it certainly isn't going to be the universal situation. And then, my Lord, there's the point she makes, her eighth point, which is to do with changing patterns and approaches to work, and what is possible for individuals to do in terms of work may in fact change over the course of their lifetime, not just in terms of their disability or their physical state, but because of technological changes and changes in the work in the work arena. As Ms. Walker said, previously it would have been difficult for a person who was housebound to do much work, whereas now they may be able to work effectively from a computer in their house. What might have been impossible 20 years ago is now possible. Adding in this sort of subjective issue into decision making will make decisions slower and decrease certainty. And at paragraph 72, what Ms. Walker says is the decision not to introduce an exception policy and instead have a bright line policy, and the bright line is contributions, is a quintessential political decision. Introducing an exceptions policy would contribute to slower decision making and greater uncertainty for claimants, as well as increasing the risk of fraud and subjective or inconsistent decision making, and increasing the likelihood that those whom neither Parliament nor the courts have decided are not entitled to would gain access to the benefit. So that is the factual background, and now I'm going to move on to my submissions on the grounds of appeal.
Yes, thank you.
So, my lords, there are 4 grounds of appeal. Firstly, that the court erred by treating itself as effectively bound by the decision in O'Donnell, which is essentially the position that this court is provisionally minded to adopt, but that's still my first ground of appeal. Secondly, the court erred in concluding that the claim status was a valid other status for the purposes of Article 14. Thirdly, the court erred in its consideration of justification. And fourthly, the court erred in its approach to the remedy that should be applied. And I'm going to deal with the second and third points first, status and justification. Then I'll come back to what regard one has to have to O'Donnell, and then I'll finish, my lord, with remedy. So, my lord, the learned judge, Mr. Justice Kerr, his judgment you find in the core bundle at page page 96. Now, it was accepted by the Secretary of State below that for the purposes of an Article 14 challenge, a discrimination challenge under the Convention, that the matter fell within the ambit of Article 1, Protocol 1. We didn't accept Article 8, and the court didn't need to decide that. At paragraphs 80 to 82, the court considered whether or not there was another status within Article 14, and that's because disability or disability plus is not one of the prescribed statuses within Article 14, but Article 14 has a category of other status, so that's why I'm talking about other status. And you'll see at paragraph 80, the formulation advanced by the claimant was being the spouse of a deceased person who was severely disabled so that she was unable to work and therefore unable to pay Class 1 or Class 2 national insurance contributions. It says that formulation is too vague to qualify. This was my submission, or part of my submission. It's too vague to qualify because it's not possible to determine who is within this class, in particular because the formulation does not refer to lifelong inability to work. But the judge says, I have no difficulty in accepting that Mr. Jwanczuk enjoys the status contended for. It's the same in substance as that determined in O'Donnell. It's clear from the word, therefore, the reason for not being able to satisfy the contribution condition is inability to work through disability. And then at 82, the Northern Ireland Court of Appeal considered the case law, etc., on other status. Conclusion was that indirect associative disability discrimination based on the disability of another was capable of being a status for Article 14 purposes. Then at 87, His Lordship said the objectives of the Secretary of State are, I accept, legitimate.
Sorry, but we've left, surely
I'm going to
I
come
thought
back.
you were addressing us on ground 2.
I'm going to come back and deal with that in a moment. I just want to take you through, just show you where in the judgment the different parts are. But
Well, I think we do know that.
so, my lord, let me go through this now then. We set out our arguments on status in our skeleton argument between paragraphs 25 to 32. Here, the status has been defined in different ways. In the
Sorry, which paragraphs in the skeleton do you say?
So no, I'm just telling you that's where it is. And
Yeah.
that's why I've set out some arguments, but I'm seeking to build on those arguments now.
Mhm.
In the judgment, in the order, Mr. Justice Kerr is, in a sense, described the status as unable to comply with Section 31(1) throughout her working life due to disability. That is a different formulation that may not make any real difference to what is set out at paragraph 80, what I just took you to, which was the claimed for status.
It's probably a better formulation, isn't it, though? Because it's more clearly focused and it incorporates the lifelong element, which you obviously pointed out isn't directly included in Ms. Callahan's original formulation.
So we're taking Mr. Justice Kerr's description. We accept that indirect associative disability discrimination, and associative discrimination is discrimination on the basis of someone else's condition or situation, but based on the disability of another, is capable of being discrimination for Article 14 purposes. That will, of course, we accept that. But here we have, that is not the discrimination contended for, because the status is not just disability, it's disability, it's what's been talked about in the cases, disability plus. It's not the disability itself that's said to be the basis of the discriminatory treatment, because there will be many people with disability who do satisfy the test. That's a precondition, is disability, but there has to be something else, and that is the consequent impact that disability has on an individual's ability to work and their failure to pay national insurance contributions. Now, in domestic law, and it may be your lordship will, and I know your lordship is familiar with this, this would be similar to the arising from disability.
Or what we sometimes call shorthand disability-related discrimination.
Disability-related discrimination.
Yep.
The section 15. Under domestic law, just for your lordship and your ladyships, it's not in the bundle, but happy to provide it if you need to. Under domestic law, treating someone unfavourably because of something arising in consequence of disability is prima facie discrimination, but it is subject to justification. But interestingly, the language of the statute, the Equality Act, section 15, does not include associative discrimination. It has to be your disability. The same applies, my lord, for indirect disability discrimination. It's got to be your disability, not someone else's disability.
Well, that's an interesting point, but we're concerned with the convention.
Absolutely, I'm just pointing that out. But the language is this is an equivalent to the section 15 provision, but it adds to it the associative status.
Now, I'm not being picky, but I just want to understand, this is This doesn't get us anywhere, does it, at this point?
No, but I'm just trying to explain to you, this is disability plus. Because
Well, you've done that already, but the point about it not being available in domestic law in an associative case is interesting, but it's not a point we need to get involved
You don't
in.
need to get involved with, and I add it for interest only.
Okay, I'm interested,
In
but
case-
not sufficiently interested to want to hear more about it.
No, my lord, I have nothing further to say on it. Our submission is that the status claimed for, so the disability plus, is imprecise, not objective, and therefore cannot be a valid status. That is what we argued below. Doesn't appear that that argument was run in the O'Donnell case. And my lord, our submission is for another status to fall within Article 14. It has to be objective and or precise. And the reason for that is so
Do you
that...
mean and or do you mean
Right, and precise. But it's got to be precise, it's got to be objective. And the reason for that is, firstly, in terms of analysing whether or not what you're doing is discriminatory, you need to have a precise understanding of the category with which you are concerned, and you need to know what evidence you would need to advance to address any justification questions. And that proposition, my lord, my ladies, was dealt with by Lord Justice Singh in the MOC case, which you find at tab 49 in the authorities bundle. Page 1466. Lord, the case concerned entitlement to disability living allowance for a vulnerable adult with severe multiple disabilities who stayed in an NH hospital for more than 1 year. And just in simple terms, disability living allowance is an allowance which is to provide you with extra money to support you in your disabled life. And there's no requirement as to how you spend it, but it's supposed to be because living as a disabled person brings greater challenges, and you may need extra money beyond the income replacement benefits to address that. The rules were that after 28 days of being an inpatient, disability living allowance was suspended. Essentially, because if you're in an inpatient, you don't need the money to spend on things outside. And there was a convention challenge under Article 14, an indirect discrimination challenge. Now, this was, as I said, it was a vulnerable adult. This was essentially trying to build on a case called Matteson, which had been to the Supreme Court, where the Supreme Court had found that a rule, an analogous rule relating to those under 16, that they would be paid DLA for the first 84 days of hospitalisation, but not thereafter, was found to be discriminatory. And the rules were subsequently amended so that anyone under 18 continued to receive payments while in hospital. Yes. And the question for the upper tribunal was whether the relevant, in MOC, was whether the relevant status for Article 14 encompassed lack of capacity. Lack of capacity. So a classic, what I call disability plus. So not only were they disabled, not only did they stay in hospital over a particular period of time, but also that they had lack of capacity. And the Court of Appeal ruled that that wasn't an Article 14 status. The Secretary of State had conceded in that case that a severely disabled adult in need of lengthy inpatient treatment was a status. They essentially had to because of the Masterson case. But it was the additional piece of lack of capacity. So that's what I'm essentially going to take you to. In his judgment, paragraph 53, Lord Justice Singh says at building what said, well, responding to what's said by Lord Wilson in Matteson at 52, where he says that if the alleged discrimination falls within the scope of a convention right, the Court of Human Rights is reluctant to conclude that nevertheless the applicant has no relevant status, with the result that the inquiry into discrimination cannot proceed. And Lord Justice Singh said, that said, it is clear from recent decisions of the Supreme Court that the issue of status is not wholly redundant. There has been some discussion in the authorities that, in a sense, one doesn't really need to consider status, because what one is really interested in is justification. He then goes on to look at issues of indirect discrimination and so on, the test for justification. And then at paragraph 61, the first difficulty with this case, Lord, if you can see that, is that the way in which it's been presented has changed at each level of the legal system. In particular, the fact-finding tribunals were not presented with the legal arguments that they've been put before this court. It is important in an Article 14 case, especially where what is alleged is indirect discrimination, to know precisely what is the alleged status that is relied upon. This affects the nature of the evidence that must be adduced, not only by the claimant, but also by the respondent. And at paragraph 65, under the issue of status, so 64, the first issue is whether there is a relevant status. Speaking for myself, I was attracted at one time during the hearing to the possibility that the relevant status is a severely disabled person who needs hospital treatment and has a deputy appointed by the Court of Protection. Miss Weston, however, was not prepared to accept that that was the relevant status. I have reached the conclusion that the judge cannot be criticising for reaching the conclusion which he did on the question of status. He was right to observe that the question of capacity as such is not a status. First, the scheme of the 2005 Act was designed to move away from a status-based approach to a functional approach. In other words, to focus on particular decisions at a particular time. Secondly, there needs to be reasonable certainty. A person's capacity may change from time to time and may do so quickly. That is not a sound foundation for the status required by Article 14. So, reasonable certainty is the proposition that his lordship is describing.
Interesting, though, that he himself was tempted by a formula that would have provided reasonable certainty, but which council didn't want to adopt.
Council didn't want to adopt.
Not clear why she didn't.
Well, Lord, that I don't know. And my Lord, at paragraph 76, Lord Justice Peter Jackson, and we have Lady Justice Andrews agreed with both judgments at paragraph 75. Says, I agree with Lord Justice Singh. The appeal does not turn on the issue of status, but I particularly agree with what Upper Tribunal Judge Ward said. It's a function of the welfare deputy to make decisions on behalf of a person lacking capacity not to provide care. The reason why this became an issue, my lord, is because the reason why in Matteson there was discrimination, even though the person was in hospital is because family members would visit, and the DLA was helpful to assist with them visiting and providing support to the inpatient. So the analogue here, presumably, was there's going to be someone caring for, supporting the vulnerable adult. That's why Lord Justice Peter Jackson said, in reality, the devoted support provided to MOC by MG was provided as a family member and not his welfare deputy. More fundamentally, I agree with Lord Justice Singh, see paragraph 65, that there are good reasons of principle and practicality why decision-making capacity does not provide a sound foundation for an Article 14 status. In my view, status is likely to be found in the disability itself and not in the separate matter of capacity, and that's the conclusion to be reached in the instant case. But there's support there by this court for the proposition that reasonable certainty in the definition is required. This, my lord, is consistent with what the European Court of Human Rights itself has said. There is in the Underhill decision in a case called Clift and the United Kingdom. It's at tab 54. It's a case concerning prisoners and different conditions of imprisonment, fixed term sentences versus discretionary life sentences. But at paragraph 55 of the judgment.
Sorry, give me the page number or tab number.
Sorry, it's tab 54, my lord. The particular paragraph I want to take you to paragraph 55, which is at page 1612.
Isn't Clift a reported case? Reported in English in the...
Oh, my lord, it may well be somewhere else. I'm not sure why this is here.
We always like to have those reports, A, because it's useful to have the head notes, and B, because in our judgments we have to cite them. So I think it may be in the QB reports. So if someone could just check.
My lord, we'll check and we'll
Thank you. Yep.
We'll make
Okay, which paragraph?
So, my lord, at paragraph 55,
Yep.
Article 14 does not prohibit all differences in treatment, but only those differences based on an identifiable, objective, or personal characteristic or status by which persons or groups of persons are distinguishable from one another. So the proposition is it's going to be identifiable, objective, or personal characteristic or status. Here
The or is a bit odd in that formulation, but sounds it might be enough if it's personal. If it's personal, it doesn't matter that it's not identifiable or objective. But
if it's a personal characteristic, because that would by itself be identifiable.
Anyway,
the
general point must be right.
You see my point, though, in respect of identifiable and objective. And then they go on to talk about, in the present case, there are specific statuses, including sex, race, and property. That list is illustrative and not exhaustive.
Yep.
And then at 56, the words other status have generally been given a wide meaning. But the point that I seek to take from this is that which you've seen. So, and at 57, they point out that, and this physical disabilities fell within the phrase other status. So disability per se is and has been found to be another status. But here we're dealing, as I said, with disability plus, and my submission is that it's not identifiable or objective.
Yes, I mean the formula disability plus isn't very helpful. What you mean is it's the inability to work.
It's the inability to work during the course of a lifetime. Yep. Because of your disability.
could that be described as, if you like, a subset of disability? Your disability is such that you are unable to work, rather than disability plus.
Well, it's the consequence of your disability. So, and
But it arises from the nature of your disability.
well, it arises maybe from the nature of your disability and the surrounding circumstances and the time in which you live.
I see.
So it's not specifically, you know, as already indicated.
Yes, but it's clear that disability is capable of being another status.
Yes?
This additional element, whether you call it a related element or a consequential element, is inability to work.
That is also capable. One can have consequential matters, and I'm not disagreeing
Quite,
with
but,
that.
what we have got to focus on is whether the concept of being unable to work is too uncertain.
Yes, yes. I'm not contending that it's the connection with disability which is the problem.
No, that's what I thought. So that's really what we've got to be focusing.
Having the disability, in a sense, is the is the entry.
That's the easy bit. That's the gateway.
Yep. It's then the question of, but what? Because you know, as we know, people work with disabilities, and the other point for my lady is, since the Disability Discrimination Act, I think in 1995, my lord will correct me if I'm wrong, but now in the Equality Act, there is a duty to make reasonable adjustments in the workplace, and therefore what may not have been, if not an inability to work, but incredible hurdles in working, are now less so in many cases because of the positive duty to make reasonable adjustments. So things have changed.
But am I not right in thinking that many benefits depend on an assessment by the government of whether you are able to work?
Not just on whether you're able to work, but whether or not it's reasonable to expect you to work in the circumstances of your disability. And I'll come on to that.
Well, I agree. So what you might need, and this may be a point that helps or it may not, but you might need a more precise definition of what is meant by inability to work. But in that, you are driven, in a sense that doesn't matter, does it? Because in the situations which we're concerned with, that decision I was going to say will already have been taken, but
it hasn't been taken. That's why there's no proxy, which everyone accepts, and that's what was it? You know, you've seen that referred to already. The question is a status.
No, but if just suppose the status was redefined somewhat, was tweaked, so that it read people who have been found to be entitled to one of the following benefits throughout their lifetime, and the benefits in question will be those benefits which, broadly speaking, and maybe using different language in different benefits, denoted an inability to work, or if you prefer, unreasonable to expect you to work.
Well, my lord, one could have that. One could describe it in that way. The question then would be: so one is that sufficiently ascertainable and identifiable? And then the question is is it justifiable for the for Parliament not to have included an exemption of that?
Oh, well,
kind?
right,
And then
but
the
I'm
question of,
absolutely, but that's justification. So,
yeah,
but the first one, if you redefined your status in that way, or perhaps
yeah,
be kinder to Mr. Callahan, refined it in that way, your problems about ascertainability or precision would disappear, because it would be a historical fact that throughout your lifetime.
So you could make it identifiable and objectively ascertainable in that way, my lord. I do accept that, because you would then be basing it on, here's another decision that's already been taken. Here is and it would be easy to answer that. There are lots of problems with it, which we can come on to talk about if you wish. People don't always apply for their benefits throughout their work.
No, quite. It would be a smaller class, because if you exclude all those who hadn't, for good reason or bad, qualified for such a benefit.
Yes. And secondly, for those who didn't live in this country for their entire working life.
Well, that would be one reason why. That's just a subset of the point I was making.
It's a subset, but I think.
But I'm just thinking this through.
Yep. But the
proxy effectively could be treated as part of the status, and then but it wouldn't include everybody who might be included by the judge's order or Mr. Callahan's original formulation.
My lord, that is right in terms of objective, identifiable.
Okay, let me just note that down.
My lord, interestingly, that has never been put forward as the status.
Well,
yeah?
no, it may not.
And
we don't know, do we, whether Mrs. Jwanczuk, if I'm pronouncing her correctly, would qualify on that status.
Yep.
I
think she may, because I think she had the equivalent of employment support allowance
from the age of 16.
From an early age.
That would appear
so
from.
She may well fall.
That would appear from either her evidence, which you haven't referred us to, and or the evidence of Ms. Walker's inquiries. So hang on 1 second. Sorry. So what I've written down is I accept that in principle a status defined by having been in receipt throughout working life of a benefit which assesses inability to work would be sufficiently precise or objective. Can I go further and say, and would constitute another status within Article 14?
I don't think I can concede that, my lord.
Why not?
I'd need to take instructions. I'm content.
I'm not sure you would actually, but I'll let you.
It may well be the answer is yes, but I can't.
Okay, I'll let you think about that.
But my lord, yes, it is ascertainable.
But the points you make in response to that are well, and then I'll just add, it may well be that claimant would succeed on the basis of such a status. Succeed on the status. Yes, it would qualify for such a status.
Yes,
sorry,
absolutely.
yes. But for the first point, anyway, not the way status has ever been advanced. Now, you may have some more substantive points, but can I just follow my own train of thought on this? If that is all right in principle, wouldn't it be equally acceptable to reach the same result by another route? To say that you could define the status the way the judge did, but require in any given case it to be evidenced by having been in receipt of such a benefit. If you, i.e. to treat the proxy, what you call the proxy, as an evidential matter, but as a necessary evidential matter rather than as part of the status, is perhaps two ways ultimately of making the same point.
My lord, it certainly would fall within another status.
Yeah.
And the question, and it would make, and if that was the boundary, those were the limits of the status. That was the category with no exceptions from it, and nothing built on top of it. Then it would be easy to ascertain.
Yes.
The question then becomes: is it justifiable? And
Quite.
And
no.
my argument would be: it's justifiable not to have that as your exempted class. And the answer to that would be yes, because of the contribution principle, and because people on those benefits.
Well, you're coming. I absolutely. I'm being perhaps rigidly analytical, and in fact, there are dicta in the case law, as you know, that the same questions tend to blur, although it's helpful to approach its status, difference of treatment, justification. Actually, quite often the same points feed into each stage of the analysis.
They do, my lord, but one of the reasons to take you to the MOC was to show you that status does still matter.
No, I get that.
And my argument is on the way in which the judge found status and the way in which the matter was argued, there was an error of law because what was arrived at and what was claimed for was insufficiently certain, insufficiently objective, insufficiently identifiable, and therefore does not amount to a status for the purposes of Article 14.
I see that.
And what you're proposing is to kind of refine it, but that's after deciding, in a sense, that the status that was contended for and found is insufficiently precise.
But if we didn't have an O'Donnell complication here, we were just deciding this ourselves for the first time. Unless you were shown to be prejudiced in some way, I think this court might be willing to be quite flexible about allowing Miss Callahan. She might look this gift horse in the mouth like Miss Weston did in MOC, but to say, well, all right, if you think the basis on which I won below is too imprecise, can I amend to redefine the status a bit more narrowly? This sort of thing we sometimes do in these
my lord,
in these groundbreaking cases. So if your only point is it's not the way it's been advanced below, I'm not sure that.
My lord, that's not my only point. But my point is, I would need first of all.
But is that your only point on status?
My lord, on yes, my.
I think it is your only.
That
point
is
on status.
my only point on status, my lord, is imprecision and.
Yes, but I'm saying that if it's redefined, then your only answer, I think, is, well, it's not been put that way below, and I think what I was suggesting to you, that might not be a good enough answer.
Yeah, but my lord, if my learned friend accepts that as the status, and that's what she contends for, then I'm happy to address that in terms of justification. Etc.
Yes.
But my
good.
lord,
okay. Well,
as you saw in MOC, Miss Weston didn't accept what the judge.
Well, we'll have to see what Ms. Callahan says about it. I'm sorry, this is a difficult case, and I'm just exploring. Don't assume that this is my view. But
so, my lord, in terms of prejudice, hopefully I'll be able to deal. I would deal with the matter in reply, and if I needed more time, I would have to ask you.
Yes,
the opportunity
but
to make
I would be
purposes.
surprised if, I mean, I think frankly I would ask you when looking at your justification arguments as one alternative
Yes.
to assume that you were being faced with the redefined status.
My lord, I will do that. But there
Okay,
may,
thank
but
you.
There, but there may be things that I haven't thought
Well, I'm
about.
sorry if this all turns out to be
No,
a
no,
red
no,
herring,
my lord.
but this is what oral
So-
argument is for, to
So my lord-
help the judge think.
So, my lord, going back to the way in which the case was put and the way in which the judge decided,
Yeah.
my submission is that there's an error of law because Mr. Justice Kerr concluded that there was a sufficient status for the purposes of Article 14 on the basis of what I've said is an imprecise and a non-objective test, and therefore outside of the jurisprudence of other status. We put this point below at and you can see our skeleton argument at, I think it's 125 in the core bundle, 125 and 126. But they're on the basis of the status.
Sorry, I was just finishing my note. Where are we going now?
Well, just to say, paragraph. I'm not going to take you to it, but paragraphs 31 to 33 of our skeleton argument below, we set out a series of arguments around status. That's at core bundle 125, 126. And
Yeah.
we say the judge didn't properly grapple with that point and reached a conclusion on status, which was.
But he basically just said the judge, they got it right
Except,
in their
except he essentially followed O'Donnell.
Yeah. Yes.
And maybe just while we're at it, just to remind you, Mr. Justice Kerr did not accept that entitlement to benefits or the reliance on benefits was a proxy for what they were actually trying to argue, which is inability to work. So therefore, they couldn't meet the contribution conditions.
Well, that's really what I was. Was he right about that?
Yes, because
Well-
they were. I mean, this is why it's shifting sands in terms of the status. But if the status is you were unable to work throughout your working life to satisfy the very limited contribution conditions, that is not necessarily inconsistent with receiving benefits, because you can work with those benefits. And I'll come on and I'll show you that.
Yes, because some of them are about. Well, you'd have to. Yes. Okay. We'll wait till we get to that part of the argument. Yeah.
But in any event, my lord, so that's my argument on status. I mean,
Yeah,
it is not a simple point, but it's a basic point. Coming to justification, and I'm going to deal with it essentially on the basis of the way in which the case was put, but I will try to adapt as we move along. The context here, as I've already outlined in my headline points, this is a challenge to a broad measure of social and economic policy. It's in the welfare sphere. It's a matter within primary legislation enacted by Parliament following a detailed consultation and in circumstances where the category complained about, certainly the way described below, was specifically referred to. And my submission is that that means that a wide margin of appreciation should be afforded to the Secretary of State and to Parliament and we say that the lowest threshold test should have been applied in terms of the intensity of review. Firstly, we're dealing here with something which is not a suspect ground. So it's disability plus. It's not disability per se, which the court...
Is it clear that a disability plus cannot be a suspect ground?
Well, my lord, that's my submission.
Yes, because
what's been found to be a suspect ground, what Lord Reed in SC says was a suspect ground, was disability. But he doesn't say disability. He's not dealing with disability plus. Because here, this is not just about people who are disabled, or even people who are severely disabled. It's those who are severely disabled and, as a consequence, can't do X, Y, and Z.
Yes, but the plus almost makes it worse, doesn't it?
No, because
The plus almost makes it more. This means effectively, if you're so disabled that you can't work, you are severely disabled. If disability is not a suspect ground, why should being very badly disabled not be a suspect ground too?
Because it's not all people who are very disabled, because many people who are very disabled work and can satisfy...
Yes, but these, by definition, are the ones who can't work.
Yeah, but you're dealing with only part of a group. So it's not just those
Yes, but
who
it's
fall within
part
that
of the
category.
group who are most affected.
It's part of a group, and the circumstances affecting that part of the group.
I mean, there may... well, as you can tell, I have some difficulty with the idea that it's not a suspect ground, but I also, if this is any help to you, and maybe a point you're going to make anyway, not sure whether the law is at the moment. We're supposed to be looking at it quite so much in sort of a box-ticking way, so that if it's a suspect ground, it automatically has to be a higher standard of review. But you'll have to show us the case law on that. I can't remember.
Well, just on MOC, just on this point, MOC, I can just show you at page 1483. So this was behind. Behind tab 49, I'm told. So, my lord, just to see the conclusion of Lord Justice Singh under justification, and just the third point, the status, whatever it may be, is not one which has to date been recognised as being a suspect ground, such as race, sex, or disability as such.
Yes, but was that not in the context of capacity, which Lord Justice Singh expressly says is a separate matter on disability?
He's found there wasn't status, but actually he deals with the issue of justification, and he's saying that disability as such is a suspect ground, but anything other than disability as such has not been found to be a suspect ground.
Where does he say that?
Yeah, paragraph 3. The status, whatever it may be, is not one which has to date been recognised as being a suspect ground, such as race, sex, or disability as such. My reading of Lord Justice Singh is he's not dealing with disability plus. He's basically saying this is a disability.
Well, I don't like these phrases like disability.
No, well, I appreciate that, my lord, but that, or disability as such, one can use instead.
I'm bound to say, like my lady, I think that's neutral. I'm not sure he was really confronting a submission like the one that you're making to us.
My lord, my submission is, and that disability, anything other than disability as such, is not a suspect ground, and therefore, when one is considering the intensity of review, it should fall within the lower level of intensity, as well as the fact that we're not dealing here with direct discrimination.
Well, that might be
Yeah.
certainly a different point.
But no, but I mean, these are cumulative, and in a sense, what SC, my lord, Lord Reed in the Supreme Court has done is he's essentially saying there is no one.
Well, that's what I was saying earlier about not taking a box-ticking approach. I think that might be a better point.
It is multifaceted. One takes into account all of the different. Because he was seeking to harmonise or to try and harmonise Strasbourg case law, where there are decisions going in different directions.
Why don't we go to those authorities soon and postpone discussion of this at the moment?
Right. My lord,
I just mark that I'm not at the moment convinced that if this is the dispositive question, I'm not convinced that MOC establishes that.
My lord, I understand that. My point is that when we take into account the various factors, we're at the lowest threshold.
Yeah, well,
and that is
fine. That submission, I'm
not direct discrimination. It's a matter of social and economic policy. It's a matter which was specifically put before Parliament in terms of a category. I've said it's disability plus or disability not, and so on. Furthermore, there are a variety of legitimate aims for the measure, and both O'Donnell and Mr. Justice Kerr have accepted that the aims were rationally connected with the measure, and they are essentially the points of rewarding work through the benefit system, which is the contribution principle, simplifying the benefit system and reducing administrative cost and complexity so that BSP is paid quickly when most needed, and promoting certainty and transparency for individuals in understanding entitlement to benefits, particularly at a time when they are suffering from bereavement. Now, my lord, the contribution condition is a central policy principle for the government and was accepted here by Parliament, and it's historically been associated with this kind of benefit, and that's what Lady Hale in McLaughlin was describing in terms of the history. And my submission is that chipping away from that principle, as is advanced by the claimant, whether in the original description of status or in my lordship's, causes a problem because it starts to undermine that principle. Of course, I have to accept that there is already the specific legislative exemptions for those who essentially died on the job.
Yeah.
But those are a very different category.
Yeah, I see that.
And they do not undermine the principle. They are exceptions which are very confined.
Or as it might be said that Parliament, having expressly thought about whether to make exceptions and having made them in the primary legislation, that's a strong argument for not putting in further exceptions.
Yes, well, absolutely, my lady. That is my point. Now, is there still a rational connection between the contribution principle and those falling either with my learned friend's original category or the category that my lord is positing? And my answer is yes, because one looks at the contribution condition on a macro level. The point is, as I've said, something for something. And you've seen reference already to the issue of, well, people are content to take a benefit if they've contributed to it. They don't want to have the stigma of being on benefits. There's also an importance in putting in something if you're getting something out. and that macro principle is undermined if one makes an exception here.
Also, I think your point is that over time, the ways in which people could qualify have changed because of technology and so on. So there might be people who absolutely weren't capable of reaching a contribution condition 15 years ago, but who could now.
Yes. And even, and as we've seen in the last 2 or 3 years, as to how the way the world of work has changed dramatically. And this is in the context of a very low threshold of condition, and they specifically wanted the threshold to be low. But the question is that satisfied? Now, the matter was addressed in O'Donnell by the Northern Ireland Court of Appeal at paragraph 98. So in O'Donnell. Behind tab 50. And towards the bottom of paragraph 98, the Lordship would say the contributory principle is extremely modest, and that extremely modest application is not under.
Sorry, where?
So, my Lord, it's at. I'm
the
on
bottom of page. So you're on page 1518 of the bundle.
1518. Sorry, 1517, my Lord.
So about halfway through, therefore.
Yep. 1517. You've got 98 in answer to those questions.
Oh, I see. Got it. Yep.
And then they deal with work. Incentivise the working. Then they say the contributory principle, my Lord. I think about 10 lines up. It's extremely modest. It's not, and they say it's not undermined by an exception being made in relation to those who through disability cannot contribute throughout their working life. An exception would simply amount to recognition that those who cannot contribute should not be excluded. That does, and I think both of us think there is a not missing from, that should say, that does not undermine the close relationship between the contribution condition and employment, merely recognising that the severely disabled are at a substantial disadvantage if they cannot work. If it wasn't the not, then there is obviously an inconsistency. It is entirely possible to make an exception without undermining the contributory principle. And Lord, my submission is that's an error of law when one considers the, and obviously that feeds into Mr. Justice Carr's decision, but it's an error of law because they are making their own value judgment here as to the relevance of the contributory principle, and they ought not to be doing so where Parliament has, they're dealing with the Northern Ireland legislation, where the Northern Ireland legislature has made that value judgment.
But also they are looking at it, potentially anyway, looking at it at a particular moment.
At a particular moment, yes.
And the point about changing abilities to work applies.
Yes.
Because the implication is that if at one point in your life you're too disabled to work, you will always be too disabled to work, and that may not be true.
And now and one is looking back over could be looking back over a 50-year period, and things do change, and then there's and my Lord, in answer to your proxy point, in a sense, the mere fact that you were able to receive one of those benefits in the past doesn't mean that you would receive those benefits today, firstly. And secondly, it doesn't mean that you were unable to work even at the lowest level required to satisfy the contribution conditions.
that right? If I was wholly unable to work and was judged to be wholly unable to work for the purpose of the relevant benefit in 1990, but in 2023, I would have been able to do a particular kind of work because of advances in technology. So what? The important point is that throughout my working life, I was unable to work. At each, if you're using my proxy approach, someone will, by the standards then applicable, have decided I was unable to work. And that's the end of the matter, isn't it? And is inherently quite legitimate.
I mean, the point I'm seeking to make is that the test might be this, even if the test is the same, the circumstances are different, and therefore
yes,
different answers may be reached.
But the test is one that has to be applied throughout your working life,
yes,
at each by the circumstances at each stage of your working life.
Yes.
The proxy I'm suggesting isn't if your receipt of benefit in 2023 of our inability to work benefit in 2023, that means that would I don't. I'm muddling myself, or you're muddling me.
I won't take that point further. The simple proposition is the contributory principle maintains a value, and it ought not to be chipped away further than it is already done in the very narrow statutorily prescribed exceptions. Secondly, there is the question of simplicity. The contribution condition, as I've sought to explain, is simple. It's easy to understand, and it is easy to administer. And it is an example of what the courts have called a bright line rule, which we say has been put in the right place, or at the very least can't be said that it's manifestly without reasonable foundation that it's not being put in the right place. And my lords, my lord and ladies, there is no discussion by O'Donnell about simplicity and bright line. In paragraph 98, even though at paragraph 95 they've set out legitimate aims which include simplifying the benefit system, and they were articulated in terms of simplifying the contributory condition, they don't address, as far as I can see, at all the question of simplification.
The one of the questions I wanted to ask was, we don't have, I don't think, the witness statement that was from, forgotten her name, Una something or other,
Yep.
that was before the court in O'Donnell. Ms. Justice Kerr says something to the effect of there doesn't appear to be any substantive difference between the evidence before both courts.
Yep.
But does that mean he saw the witness statement that was before the court in O'Donnell, or was he merely going from the summaries of it?
He was going from the summary. He in O'Donnell they had a witness statement from Una McConnell, who I think is from the relevant Northern Ireland.
Yes, quite.
To paragraph 10, and there was the witness statement that Helen Walker had put in for the Jackson case, which is the case involving.
Yes, but that's directed to a slightly different point.
To a different point.
Although it has a background about the legislation.
So they didn't have. So to that extent, Mr. Justice Kerr is wrong in terms of he had different evidence in front of him than the court in O'Donnell. But the summary that's set out in Miss McConnell's evidence, is essentially the background, which I've articulated some of that to you today. But you don't have that.
No, we can obviously, we don't need to have it. I just wanted to make sure that the judge didn't have it either.
The judge didn't have that, and the judge didn't have Helen Walker's statement in Jackson. He had her statement here.
Right. Okay, thank you.
So, my lord, as I've said, there is no analysis, there's no consideration in paragraph 98 or elsewhere of the simplicity point, which I say is one reason why O'Donnell should not be followed. But the point was advanced, and is considered here by Mr. Justice Kerr, but he didn't accept the arguments. Now, we set out in our skeleton argument at paragraph 36, page 31 of the core bundle. 31 core bundle, para 36. The general proposition, legislation may be justified by the need for a bright line rule. Legislation cannot be framed so as to address particular cases. It must lay down general rules. The general rule means that a line must be drawn. It's for Parliament to decide where. The drawing of a line inevitably means that hard cases will arise falling on the wrong side of it, but that should not be held to invalidate the rule if judging around it is beneficial. And there is a whole series of cases on that, which I don't think I really need to take you through, because they all eventually come back to that same point, which is there is merit in a bright line, but there are questions as to whether or not it's reasonable beyond manifestly without reasonable foundation to have placed it in a particular place. But there is a recognition that that it can be put in the right place, even though there will be hard cases on the other side of the line. And it may well be that this is an example of where there are hard cases. But that doesn't by itself undermine the line itself and where it has been put. The question really is the justification for the policy so weak? And this you get in the RJM case, which is at tab 25. It's at one of the, I think it was the House of Lords then. No, it made Supreme Court. But in RJM, tab 25, paragraph 57, Lord Newberger. No, it is House of Lords, yeah. So it's page 617 in your bundle. And it's these words. The fact that the line may have been drawn imperfectly does not mean that the policy cannot be justified. Of course, there will come a point where the justification for a policy is so weak, or the line has been drawn in such an arbitrary position, that even with the broad margin of appreciation accorded to the state, the court will conclude that the policy is unjustifiable. Now, my submission is that the policy justification is not so weak in terms of the contributory principle and simplicity and certainty, and the line hasn't been drawn in such an arbitrary position as to be manifestly without reasonable foundation. Because here there are especially good reasons for having a bright line and drawing it where it is. We're dealing with allocation of resources in the welfare context. The contribution requirement has a clear rational basis. There is a need for quick decision making given the circumstances surrounding bereavement and the goal of the payment to tide over financial concerns in the immediate aftermath. You don't want to have complex decision making, and you don't want to have too much of a requirement where you have to interact with the applicant. They want certainty. They need to be able to plan in advance of the death as to what they are to expect. It needs to be easy to understand and to apply. Now, my lord, I would accept that if your status is the accepted status, that issues of complexity, and if it's that with no analogues, that you have to have been in receipt of one of the incapacity benefits throughout your working life, that would address the issue of uncertainty and administrative complexity, because it ought not to be. It might be a little bit more difficult because you'd have to go back.
You still have to go back into old systems.
You'd have to go back into old
so
systems.
Ms. Walker's evidence would still be
but
relevant.
It would still be relevant, but I can see that it would be less of a task. You know, one is looking there for, is there positive evidence of receipt of benefits at a particular point in time? So I shouldn't abandon the complexity and quickness and certainty point, but I think it is, I accept, less powerful in those circumstances. But certainly the contribution requirement would be undermined. And undermined in a more significant way than if it was the test of unable to work at all during your working life, or unable to work so as to meet the contribution conditions, because you can work, or some people who are on those benefits can and do work. And I'll just show you how that operates in terms of the statutory scheme.
Yeah.
Because this is part of the point as to why there is no proxy. So, well, if we look at the legislation around employment support allowance, which was introduced as part of the Welfare Reform Act 2007, behind tab 5, my lord, it's page 33. An allowance to be known as an employment support allowance shall be payable in accordance with the provisions of this part. You're entitled to it if you satisfy the basic conditions and some other conditions which are not particularly relevant to this, but the basic conditions are that the claimant, and it says, has limited capability for work, and that is defined at 1.4 for the purpose of this part. In other words, for the purposes of obtaining this particular benefit, a person has...
Sorry, we just... this... I ought to know this. I've done one or two universal credit cases. Universal employment and support allowance fits into the universal credit structure, does it?
Yeah, it predated universal credit, but and there still are legacy people, even though there is universal credit now. But this is looking at this. Just
remind me, which was the act? I thought Welfare Reform Act 2007 was the act which introduced. No, it is. No, of course not. It wasn't.
It was.
No. Okay, that's what's confused me. Yep. Okay, got it.
If it may assist, the 2007 Act introduces employment support allowance. The 2012 Act at the next tab introduces universal credit.
Yes, I'm sorry. I was just confused by the similar title of the two acts.
And there are interactions between. First of all, there's legacy, and then there's interactions.
Yeah. Okay, but thank you. No. Keep going.
Yep. So 1.4 for the purposes of this part. So that for the purposes of obtaining this particular benefit, a person has limited capability for work if his capability for work is limited by his physical or mental condition, and the limitation is such that it is not reasonable to require him to work. But that is not, they can't work, but it's not reasonable to require him to work so as to obtain the benefit. Because this is essentially an income replacement benefit. So you're not required, we don't think that you are required to work so as to obtain this particular benefit.
But it doesn't follow that you aren't able to.
It doesn't follow you're not able to work. And in fact, the scheme specifically contemplates that you might be working whilst you are on employment support allowance, and you do not lose employment support allowance, even if you are working in those particular schemes. And I'll just show you in the regulations that apply here, which are it's at tab 11, they're the Employment and Support Allowance Regulations 2008. And I'm going to take you to Regulation 40.
Hang on 1 second.
I'll just find you the page. I'm sorry.
Page 77.
Page 77, thank you, my lady. Claimant who works to be treated, heading is, to be treated as not entitled to an employment and support allowance. So it says, subject to the following paragraphs, the claimant is to be treated as not entitled to ESA in any week in which they do work, but that doesn't apply to...
Sorry, you've got
So
a
it's
bit
page
ahead.
77, it's
Yes, I
kind of
got
a
it,
double
yeah.
negative.
Yeah,
But
got it, yes.
if you work, you're not entitled to ESA unless you're doing the following kinds of work. So that doesn't apply to A, work as a counsellor, which is a local authority counsellor, then a member of a first tier tribunal for 1 full day or 2 half days a week, domestic tasks carried out
Yeah,
at
well,
the
we can see the various exceptions.
etc., etc., etc. And then there's exempt work.
Yeah,
And then Regulation 45, so, which is the exempt work, which is at page 85. Work for which the earnings in any week do not exceed £20. Work for which earnings in any week do not exceed 16 times the national minimum wage and is part of a treatment programme or is supervised. Work which is done for less than 16 hours a week for which earnings in any week do not exceed 16 times national minimum wage. So
yeah, but I take your point entirely, but isn't it a bit over stark, the distinction between inability to work and not reasonable to require someone to work? Although I didn't particularly like Mr. Callaghan's specific example of the disabled person who can haul themselves up the stairs to escape a fire, inability to work is always, to some extent, except in the most extreme cases, relative. Many people who many people could work for a bit under extreme pressure, but it's not a black and white distinction. And all your example illustrates is that Parliament has recognised that.
yeah, well, Parliament has recognised that you're not reasonably required to do anything other than that to receive this particular benefit, because it's a question of it's what's called an income replacement benefit. So for those who are
Yes, but it might still be a reasonable. All I'm trying to say, it might still be a reasonable proxy for inability to effectively inability to earn national insurance contributions
my
at
Lord,
the right level.
my submission is that it's not precisely because you can work, and the
But is the work is some of the work you could do work from which you would be able to satisfy the national insurance contributions requirements?
So interestingly, the 45.3, or sorry, the 45.4, regularly 45.4, is work which is done for less than 16 hours a week, and it's at national minimum wage.
Yes.
That would bring you just below the £190.
Is that an accident, or is that actually? So
They're not related at all. This is a completely different statute. I mean, this is why these are two completely different schemes.
Also, you may not be comparing like with like in terms of the time.
Yeah, well, you're not comparing like with the time, but this is a completely different system. Basically, there's an encouragement for people, even though you're not going to lose your ESA if you work up to 16 hours a week.
in these particular types of work?
No, this is any work.
Oh, yes.
Which is done for less than 16 hours a week. It could well be the case that people could work for more than 16 hours a week, 18 or 19 hours a week, which would then, for that 1 week, you only need to work for 1 week at £190 a week. I think minimum wage is around £10, I think, or just under £10 an hour. So it's around £160. So it's above the lower earning limit, but just beneath the qualifying amount for that 1 week. If you worked 2 extra hours, you would pay your national insurance contributions. Now, it may well be that people who work under the 16 could work the extra 2, but they don't because they'll lose their ESA because of it. But my point is, this is a completely different statutory scheme. It's designed to do something completely different.
No, I understand that.
And it's not a proxy for inability to work. And if you feed it back then into the justification of the contributory principle, these are people who can work. And it may, and if they just worked an extra 2 for 1 week in their life, worked an extra 2 hours on minimum wage, they would satisfy the conditions. So, going back to how O'Donnell, Lord Justice Stevens then in O'Donnell was, well, it wouldn't undermine the contributory principle. My submission is that it would.
And what are the other benefits for which might be used as a proxy? Is this since the coming into force of the 2007 Act? Is this the only benefit that?
This is the analogue to invalidity benefits, incapacity benefits, so the historical benefits. How it works under universal credit, I can't.
But that may not matter.
But essentially, this is the. I think the claimant was on ESA.
But I suppose my point is that if you are on ESA, you are not able to work to an extent that would enable you to make national insurance contributions.
If you're on ESA, yes.
So adopting that as a proxy would mean, if you're on ESA throughout the relevant period, suppose you become 16 in 2008, that would mean, that would be good evidence and workable evidence that you were not able to satisfy the contributions requirement.
Well, but my lord, I've just shown you the provision which says you can work up to 16 hours at national minimum wage and not lose ESA.
Yes, I understand that, but unless I'm misunderstanding you, you also said you couldn't earn quite enough under that to be in a position to satisfy the contributions requirement.
Yep.
But your point is, it might be at your option whether or not you satisfied the requirements for ESA.
Well, in terms of that,
Yes,
I can
in
see.
terms of that
I'm not,
scheme.
and I'm not saying anything about the claimant in this
Yeah.
case, and I'm not.
So in other words,
making-
you're saying the fact that you've got ESA throughout isn't an accurate proxy for the status that was found in O'Donnell.
No, that certainly is the case, but it would be an accurate. Why would it not be an accurate proxy for being unable to satisfy the contributions requirement?
If you're on ESA, it means that you, and I'll be corrected if I'm wrong on this over lunch, that you're not able to work. You're not allowed to be on ESA and work enough hours in 1 week so as to satisfy the contribution condition. Yeah, that
Now, I
is
appreciate you, of
correct.
course, could then work more, and then you wouldn't get ESA.
Yeah, I think.
But then you would, if you worked enough, then if you did it for a year, satisfy the contribution.
There may be an exception, which I'll need to check about a councillor in a local authority, because a councillor in a local authority will receive an allowance, and I need to just check whether that allowance is a class 1 or class 2 matter. Because
I may have made difficulties for everyone by suggesting this alternative.
my lord, can I just
I see the time.
just before you,
Yes.
can I just make one point on this, just because it's important not to necessarily read across from one set of legislation to another, because they're there for different purposes. And just in an analogue to this was in the Supreme Court decision in SG, which dealt with the benefit cap, which is behind tab 29. Case for SG against the Secretary of State for Work and Pensions. I think we're in law, and we're in judgment of Lord Reed. And that was a question about whether the benefit cap, which is there's a cap as to the amount of benefits you receive, was indirectly discriminatory towards households with children. So it's behind tab 29, page 786, para 40. In relation to the impact of the cap on households with children, an amendment seeking to exempt single parents with children under 5 was opposed by the government in response to the argument that since such parents were not obliged to seek work in order to be eligible to receive benefits, they ought also to be exempted from a cap on the amount of any benefits which they might receive. The minister stated that the cap was intended to act as an incentive to work. So, cap is an incentive to work, even for people who are not obliged to work so as to receive their benefits. And his lordship says, although single parents with children under 5 were not required to seek work as a condition of receiving benefits, that did not mean that the government did not want to encourage them to find employment. The amendment would undermine the fundamental principles underpinning the cap, that ultimately there had to be a limit to the amount of a benefit that a household could receive, and that work should always pay. Now, it's an analogue to your point, my lord, because the mere fact that you've got one statutory scheme, which is based on certain principles, which appear to be inconsistent with another statutory scheme, doesn't make that other statutory scheme manifestly without reasonable foundation if its own policy aims are justifiable. And I will finish my submissions, my lord, this afternoon.
You finished very early this afternoon.
Early this afternoon.
Yes, that's fine. Have we got a bit more on justification or not?
My lord, I think I'm almost concluded.
Yes, so it's really just O'Donnell.
And then it's O'Donnell.
Yes. Okay. Well, I cherish a faint hope, because Mr. Callaghan won't have to take so long of our finishing this afternoon, but if we don't, we don't.
My lord.
Court rise.
No chance. Not if I know you.